What's up, guys? Brian Fellow Law Group PLLC here with your Florida Law Weekly Case Update. Happy holidays. Merry Christmas, everybody. Got 4 cases for you this week. Let's get right to it. First case is out of the 5th DCA, Martin versus Sater. And this one is super interesting because it has to do with setting aside a marital settlement agreement when there's already been a final judgment entered. So basically what happened in this case happens, quite often. Parties resolve the matter pre-suit, pre-filing divorce. Parties attended mediation. I don't think they had lawyers, but they attended mediation and resolved the matter themselves. Enter into a marital settlement agreement. Incorporate that into a final judgment of divorce. Get divorced. Then later on, not within the 1 year apparently, somebody files a motion to vacate the final judgment and set aside the marital settlement agreement. So the question becomes, what is the standard? Are you able to set aside a marital settlement agreement based on the Casto v. Casto standard, which basically allows somebody to do it, to set aside an agreement if it's unfair, unreasonable, then the burden shifts to the other party to show that they gave full and frank financial disclosure, and you go through that whole process. Are you allowed to use that Casto v. Casto analysis post-judgment in a case where there's already been a final judgment entered? Apparently not. The court said, this is the 5th DCA. There was a prior case in the 5th DCA that I guess somewhat allowed parties to do that. Court 5th DCA says now, no, absolutely not. If there's been a final judgment entered, you have to set aside the final judgment itself under 12.540, which only allows parties to set aside an actual judgment based on those specific factors listed in the statute, one of which is fraud. So you can still set it aside based on fraud or material mistake of fact, that kind of thing, but not based on unfairness, unreasonableness. You don't do that burden shifting, lack of financial disclosure kind of a thing. No, you have to solely follow 12.540, at least in the 5th DCA. They certified conflict, and we'll see if the Florida Supreme Court actually takes this up. They certified the question actually to the Supreme Court. So we'll see what happens. But that's my understanding. There was another case I talked about earlier this year. It was the same thing. I think it was out of the 6th DCA, I believe. Whereas the same idea, Casto v. Casto does not apply post-judgment. Post-judgment, the only thing that matters is 12.540. Next case is Lally versus Lally. This is out of the 4th DCA. This has to do with the relocation. This happens often, sometimes in my cases. But basically, so what happened here was interesting. The father petitioned to modify the timesharing and to relocate. He was not the custodial parent. He petitioned to move to North Dakota, saying he got a new job, but apparently he got that new job 3 years ago. And he wanted permission essentially to move to North Dakota and to modify the timesharing schedule so that he would have a long distance parenting plan. Essentially, he wanted like 9 days out of every month. And so, but what happened during the actual case? He unilaterally relocated anyway. So he's already in North Dakota. They go to a trial on essentially like both the supplemental petition to modify and the relocation. The trial court essentially denies the relocation, says it's not in the children's best interest for the relocation, but finds that regardless, the court found that it had, essentially power to modify the time-sharing schedule in the children's best interest. And the court made up its own parenting plan. It didn't even go with the father's proposed parenting plan or anything like that. It made up its own parenting plan. On appeal, former wife, mother, she appeals and she says that the father failed to prove his case for a relocation and failed to prove a substantial change in circumstances warranting a modification of the timesharing. Essentially, the appellate court agrees. The appellate court says because he already relocated without even getting permission and he wasn't the custodial parent, the relocation statute basically didn't even apply anymore. Like he wasn't even traveling under the relocation statute, and really what he was traveling under was the modification statute, which is 61.13, not 61.13001. Not a relocation, just a modification. And the court held the long-standing, theory or ruling that the relocation of a parent in and of itself, the non-custodial parent, relocation of non-custodial parent in and of itself is not sufficient to constitute a substantial change in circumstances under 61.13 to modify timesharing. So if you're going to try to modify timesharing based on your unilateral move and then say, okay, now I'm moving to modify timesharing, you can't do that. Basically, if you travel under the relocation statute, then you can get a modification. My understanding, you can get a modification pursuant to the relocation statute, but not solely based on your own move under 6113, general substantial change of circumstances. That's not going to be enough. Next case is Russell versus Mells. The only reason why I'm citing this case is this thing that even experienced lawyers, this lawyer I think in this case has been a lawyer for like 30 years or maybe more. What are they doing? They're using AI to write their brief and citing phantom cases. Hallucinations is what they call it. You gotta not, just don't do it. Just don't do it. You have, even if you use AI, which I sometimes use AI to help write certain briefs or things like that, but you still have to go back and edit your own work and look up the cases that you're using and then you're citing in your brief. You cannot use phantom cases. Don't do it. You got to look up every single case that you're citing. Go back and do your work, edit your document, review your document, and write it yourself if you need to. So this is another lawyer got in trouble with the Florida bar for citing phantom cases. That's just one thing you cannot do. Even if you use AI, do not cite phantom cases. Next case is out of the first DCA, I believe. Actually, I think this is the sixth DCA. No, sorry, third DCA. And this is an appeal of an amended final judgment. Amended final judgment. You might think, well, I can just wait until there's an amended final judgment and then that's what I appeal. Wrong. Too late. Too bad. Too sad. If you're going to appeal something from that was already in the substantive final judgment, even if it's amended, you have to file your notice of appeal of the actual original final judgment. You cannot wait for it to be amended, because if it doesn't correct what was already in the final judgment, it's going to be too late. It's going to be untimely. So make sure you file your notice of appeal of the original final judgment. Might as well just do it. All right, guys, that's it for this week. I hope everybody has a wonderful break if you're taking a break for Christmas, and we'll see everybody next week. Take care. Bye.